Hi, everyone. So thank you very much. I'm going to let Mrs. Kabo, who is working at the AfCFTA Secretariat as a legal counsel and expert, to make the to deliver the first speech and introduce our panelists. Thank you.
Merci bien, Monsieur Karim. Je suis Madame Kabo Balkissou. Je suis expert juridique au secrétariat de la ZLECAf. Je suis magistrat de formation. Je viens du Niger. J'ai été détachée par le Niger pour aider la mise en œuvre de l'opérationnalisation plutôt du secrétariat de la ZLECAf. Et donc, le panel ayant pour titre le règlement des différends, on avait prévu 5 panélistes, mais on se retrouve avec 3. Ou bien les autres vont nous joindre après, ou bien on va faire seulement avec les 3, M. Karim.
Alors, nous allons commencer d'abord avec les 3 intervenants, et si jamais nous sommes rejoints par les autres, nous pourrons leur donner la parole. Je vais juste traduire votre introduction. So Mrs. Balkissou, as I said before, is an expert and legal counsel at the AfCFTA Secretariat. She's a magistrate and judge. She was educated in Niger, and she's currently in secondment at the AfCFTA on behalf of the state of Niger, and she will be chairing the session today.
Ok, merci. Avant d'aller en profondeur, je tiens sincèrement à féliciter et à encourager la Société africaine du droit international pour l'organisation de cette conférence et pour l'opportunité donnée au secrétariat de la ZLECAf pour sa participation. Et ceci, je suis convaincue, c'est afin de l'aider à mieux s'implanter à travers le continent et de bien démarrer l'implémentation de son accord cadre. Et je félicite également les panélistes ici présents pour avoir accepté de se joindre à cet exercice combien important et bénéfique, aussi bien pour les participants, bénéfique pour les organisateurs et aussi bénéfique pour le développement de toute l'Afrique.
So Mrs. Balkissou would like to thank the African Society of International Law for organizing this year's event. And on behalf of the AfCFTA Secretariat, she's convinced that this event will help with the implementation of the new African trade. She also congratulates the panelists that you can see on screen now to be part of this panel and to share their topic with the audience today.
Comme vous le savez, l'un des instruments juridiques africains a laissé sa trace dans l'histoire de l'intégration économique du continent serait sans nul doute l'accord portant création de la ZLECAf. Et l'objectif principal de cet accord demeure le renforcement des relations économiques des États africains à travers la création d'un marché élargi et sécurisé pour les marchandises et les services des États parties. Et ceci grâce à une infrastructure adéquate et à la réduction ou à l'élimination des barrières aussi bien tarifaires que des barrières non tarifaires et au commerce et à l'investissement. Donc, si je peux dire, la ZLECAf se veut d'être un forum de négociation permanent parce que, comme vous le savez, on avait déjà commencé à la première phase et avec la première phase, on est en train de faire l'implémentation. La première phase des négociations continue et la deuxième phase a également été lancée comme la directrice Émilie venait de l'évoquer tout à l'heure. Donc, je disais que la ZLECAf se veut d'être un forum de négociation permanent entre les États parties et serait donc une organisation, si je peux dire, de coopération et d'intégration plus poussée entre les Africains, conformément au protocole, au contenu de l'accord.
So in a nutshell, Mrs. Balkissou is introducing the the AfCFTA, the trade agreement, as being a means for African countries to negotiate and also create a forum for them to reduce or eliminate tariff barriers, and also to increase trade and investment in Africa. So she also repeated Mrs. Murundoria, who is also part of the AfCFTA Secretariat. She repeated the words as a willingness to increase the cooperation between African countries.
Et donc, pour revenir au titre de ce panel dédié au règlement des différends, il me plaît de vous rappeler que l'organe de mise en œuvre de ce cadre de coopération qu'est l'accord de la ZIRECAF et que le secrétariat a été établi et comme l'avait soulevé tout à l'heure, les échanges entre les États parties avaient débuté le 1er janvier 2021. Et donc, je peux préciser aussi que ce cadre d'intégration économique dispose d'un mécanisme de règlement des différends qui en fait d'elle un ordre juridique semblable à celui de l'OMC, parce que les panélistes ont évoqué également la relation entre le mécanisme de règlement des différends de la ZLECAF et celui de l'OMC. Ainsi, depuis l'adoption de l'accord portant création de la ZLECAF, le protocole sur les règles et règlements des différents constitue le cadre légal efficace et efficient de contrôle, parce que c'est à travers la mise en œuvre de ce protocole qu'on peut contrôler le suivi et l'implémentation de l'accord cadre, parce que tous les différends qui surviendront seront soumis au mécanisme élaboré et mis en place par ce protocole.
So the AfCFTA has its own dispute settlement mechanism, as the WTO has, and you will hear one of the panelists sharing his thought on this mechanism in light of what the WTO also implemented. And Mrs. Balkissou emphasized on the fact that the dispute settlement mechanism is crucial to make sure that the trade agreement is implemented around the continent.
Aussi, pour ce qui est du débat qui nous réunit aujourd'hui dans ce panel, à savoir le règlement des différends dans le cadre de la ZLECAF et les accords internationaux africains relatifs à l'investissement, tout en soulignant que les présentations, parce que j'avais un peu suivi les présentations, tout en soulignant que les présentations qui seront faites contribueront à enrichir davantage nos connaissances sur les différentes panoplies de procédures de règlement des différends dont dispose notre continent. Et les présentations nous permettront également, nous du secrétariat, nous spécialistes du droit, nous pratiquants, et de savoir ce que les Africains attendent du mécanisme ZLECAF de règlement des différends. Donc, je tiens ici à féliciter toutes les parties prenantes à cette conférence annuelle et leur rappeler les attentes vraiment des États et du marché africain des affaires relativement en ce qui concerne leur rôle et leurs responsabilités. Donc, et je vous remercie tous.
So this panel on dispute settlement today is crucial also for the Secretariat to know what people are expecting with the new trade agreement. It will also allow the audience and people all around the world to increase their willingness, but also to know more on the dispute settlement mechanism. And Mrs. Balkissou would like to thank again the panelists for sharing their thoughts and also being part of the discussion, because it's an important topic. And she also thanks the African Society of International Law again for organizing this conference.
OK, sans pour autant m'accaparer trop de la parole, je vais peut-être procéder à la présentation des panélistes. Je vais commencer par M. Harrison Mbori. Et nous avons dans ce panel M. Harrison Mbori, qui est diplômé de Master 2 en droit. Il est doctorant à l'Université de Loyola à Chicago. Il est également chercheur associé à l'Institut Max Planck de Luxembourg pour le droit procédural et plus spécifiquement au département du droit international et du règlement des différends. Welcome, Mr. Harrison.
So we are now welcoming Mr. Harrison Mbori, who graduated with a 2 master's degree. He's also a PhD student at Loyola Chicago Law School in the United States. He's also a research associate at the Max Planck Institute in Luxembourg, and he's specializing in public international law. So please, Harrison, the floor is yours.
Merci, Madam Kabo. Thank you. Karim, I just want to share my screen. You can tell me whether you can see it. I'm just trying to do it now.
Yes, we can.
We can, please. Let's go. We can go.
Okay. So as introduced, my name is Harrison Mbori, and my presentation is on the MFN clause in the AfCFTA. So it's not directly related to the dispute settlement mechanism itself, but what the dispute settlement mechanism itself is going to face with dealing with this MFN clause in the near future. I'm happy that Professor Gadhi has mentioned this a bit, so I zoomed in on this MFN clause, and now let me say clauses, and possibly principle, and possibly obligations in the AfCFTA. And you'll see why I am saying all of that in a single sense, because it's not just one clause, it's a number of clauses in at least the 3 main instruments of the AfCFTA. So the outline of my presentation is to do a general introduction, and then to sort of give an idea of the 4 different emanations of the MFN in the AfCFTA, and provide a bit of an analysis of the MFN provision as a principle, and then as a general rule of continental preferences, and then as a general discipline of non-discrimination in the protocol on goods and in the protocol on services. Let me just mention that as we see it, the dispute settlement agreement or protocol of the AfCFTA is a carbon copy of the WTO dispute settlement system. So if you have an idea about how the WTO dispute settlement system works, that's exactly how the AfCFTA system protocol looks like. Not so many tweaks have been made. The general architecture of the system is the same. So the panels, if I say that, of the AfCFTA and the appellate body of the AfCFTA that we're going to see in the future will have somehow to deal with these MFN provisions that are found in the AfCFTA. Now, let me just, for purposes of people who do not do trade every day, I must sort of do an introduction of what the MFN obligation is. It's not just I shouldn't assume that everyone knows what it is, but just briefly, you can think about it from a bilateral point of view and a multilateral point of view. From the bilateral point of view is when 2 states are negotiating a trade or commercial related agreement, and they decide that when one country gives the other country or the other state favors, advantages, or immunities, those that it has granted to any other third party are also going to be granted to the party that they are negotiating with or the party that they are entering into an agreement with. So that is at the bilateral level. If you give anyone that you give any advantages, favors, immunities, you're going to grant them to the party whom you're negotiating with. So you're going to make them a favored nation. You're going to treat them as well as you're treating third parties wherever they are. But it can also be a multilateral provision. If you have more than 2 states involved, you can say that if one state gives advantages or favors to states outside of the multilateral agreement, then they're going to also grant those favors to the parties who are inside the agreement. So you can look at it at the bilateral level, and we can also look at it at a multilateral level. However, the story doesn't stop there with MFN. MFN can also be, at least historically, either conditioned on compensation or reciprocity, or conditioned or unconditional and immediate. If it is unconditional and immediate, like it is in the WTO agreement, it means that, the parties inside the WTO get the favors, the advantages and immunities that have been granted to every party inside the WTO and also outside the WTO immediately and unconditionally, without paying any compensation, without doing any sort of reciprocity. That is the backbone of the multilateral system. So it is sort of a members club kind of a system. If you are inside the club, you get the MFN status, especially the WTO multilateral unconditional treatment that we see in Article 1 of the GATT. So if you are inside the club, you get all the advantage, favors, immunities, and that have been granted to third parties and to WTO members immediately and unconditionally. But that is not the traditional idea of the MFN. In fact, the MFN began as a conditional standard. And when it is conditionalized, it sort of bilateralizes and makes the relationship between the parties more a discrimination kind of a relationship than a multilateral kind of a relationship. That is why the GATT went for the unconditional and immediate kind of MFN. And the biggest disadvantage of the unconditional and immediate MFN is the problem of free ridership. If you have ever gone into an international trade law class, you've definitely heard that this is one of the bigger problems of the MFN provision, at least the iteration that is found in the GATT. And now sort of have a good idea of how the MFN works. You enter into a club, and now we can start thinking about, what about if you are in a mini club? So the WTO is a big club, but the WTO itself also allows parties to enter into mini clubs. And those mini clubs are the regional trade agreements or the preferential trade agreements that are mainly allowed under Article 24 of the GATT and also allowed under the enabling clause. So the AfCFTA is part of this mini club. Now we need to start asking ourselves, how would an MFN clause work in a mini club? What are some of the things that we should be interested about? Should it go unconditional, or should it go the unconditional immediate direction, or should it go the conditional on compensation or reciprocity direction? And what else can be added? How can it be written? How can it be negotiated? The good thing about this is that we already have the agreements. So we can look at the agreements and see the kind of provisions that are there in the AfCFTA. And I said previously that there are 4 different iterations. On this slide, I just provide a quick glimpse of them. They have more paragraphs in these provisions. The first one is Article 4 of the Framework Agreement, which contains the establishes the AfCFTA, the wider agreement, which we should maybe call the Kigali Agreement after the analogy from the WTO as a Marrakesh Agreement. I don't know whether my senior colleagues or others will agree that that's a good way of calling it. It just provides in Article 4 that MFN is a principle, is an operating principle of the AfCFTA. But in the same agreement in Article 18, you find MFN as a rule of continental preferences. And now here we're getting into the real meat of the MFN. And it says, that following the entry of the agreement, state parties, when implementing the agreement, will accord each other on a reciprocal basis preferences that are no less favorable than those given to third parties. Now you see, we have reciprocity, and in a large sense, we have a conditional MFN, not the same as the unconditional immediate MFN that is found in the WTO in GATT Article 1. So this is different. This is not the same. This is reciprocal, and it is concerned with favorable treatment that you can possibly grant to third parties. Then these 2 other provisions, these are common Article 4s. The Article 4 in the Protocol on Goods of the AfCFTA and Article 4 of Services also provide for the MFN obligation. You'll see that the one for goods is very similar or has some similarity. In fact, if you read the text, it's piggybacks or it makes references, it references back to Article 18. And you'll see that Article 4, at least paragraph 1, because we'll see this is more complicated, introduces possibilities of immediacy and unconditionality, going more to the language of GATS in Article 2. But this is just the first paragraph of the services. So the first three obligations seem to be going towards conditionality, seems to be going towards reciprocity. The third on services seems to be going the other side of providing immediacy and conditionality. But as you'll see, the story is much more complex than that. It is because of this 4 iterations that I make 2 arguments in this paper. The first argument is that these 4 different iterations of the MFN obligation as part of a singular key of the AfCFTA will prove confusing in both implementation and interpretation by future panels and appellate body of the AfCFTA dispute settlement system. I foresee, and I am not a Jewish prophet, but I foresee it is going to be an arduous task that lies ahead in the harmonious interpretation of these provisions, especially when it comes to disputes, if they will ever arise on essential goods or services that might arise under the AfCFTA. But that is the dispute resolution difficulty and interpretational difficulty that I see. I also see that there's a possibility that this choice of conditional MFN on reciprocity in the AfCFTA framework, to me, shows that African states are not yet ready for a full trade liberalization that some AfCFTA members have already offered to non-African countries. Therefore, if not carefully handled, this choice of MFN has the possibility of stifling the great potential of the AfCFTA generally. And I think this is part of the threat that Professor Gadhi was talking about. So if we do not handle this really, really carefully, this choice that we have gone with, it might be problematic. And this is why it might be problematic. So the first one is, we just have the MFN as a principle in Article 5 of the AfCFTA. And I'm saying here, without any other words, MFN appearing alone in a treaty text to be interpreted textually as a principle in its ordinary meaning, based on Article 31 of the VCLT, is a bit difficult to see, what exactly does it mean as a principle, because I've already said that the history of the MFN is quite convoluted. It's not a singular norm that stands on its own. It's just, and therefore, if a principle is this wide species or of a basic underlying assumption, the MFN does not, as an obligation, or does not lie on itself to becoming a principle. It's difficult just because of how it is. It has to be written as a rule, because we need to know, is it conditional, is it unconditional? So having it as a principle, to me, is a bit disturbing. And I don't know what the intention of African states or our intention was with this. What I can say in terms of interpretation is that it is difficult to know whether that principle has a substantive or a procedural content. And I don't see a substantive or a procedural content of the MFN obligation as a principle, because without any further words, we cannot tell which variant of the MFN obligation is covered. And that is without reading Article 18. And then even if you read Article 5 in its context, you find other broadly worded principles that are difficult to call principles within the legal meaning of the term principle as we understand it in international law. So the other principles are driven by member states of the African Union. Rex free trade agreements as building blocks. Variable geometry is part of it. MFN is inside there, and national treatment, just like that, without saying any more. And the other principle that is found in Article 5 is reciprocity, which I have said can actually be, a different idea from the MFN obligation. Now, the MFN obligation has been, the ILC itself has been interested with the MFN obligation. 2 reports. One was done in the 70s, and they came up with draft articles on the most favored nation clauses. This, I think, has been forgotten by very many scholars and even practitioners in international trade law, just because of how ubiquitous Article 1 of GATT has become. These draft articles have been forgotten. And it is because of these draft articles that I'm actually saying, the idea of going with conditional reciprocity in the MFN clauses is not in itself untraditional or not known in international law. It's a choice that is acceptable. In fact, that is what the second report of the ILC in 2015 seemed to be suggesting. And this second report of the ILC in 2015 was mainly dealing with the MFN, with the controversies that began with international investment, bilateral investment treaties and MFN obligations therein. So it was not so much in 2015 what is in trade, because the assumption had been that Article 1 is ubiquitous, everyone knows it like that. And that is why they're saying here that while the core function of the MFN clause is often seen today to be its automatic and unconditional extension of benefits, the 1978 draft articles contained detailed and lengthy provisions on the conditions of compensation and conditions of reciprocal treatment. So we are not in a bad ground there. The main takeaway from this is you can have conditional and unconditional MFN. It's the choice of the states. They decide what they want, and we African states decided we want to go with a conditional, non-automatic, reciprocity-based MFN provision. So this is not new in international law. It is an acceptable choice, but choices do have consequences. And here are some of the consequences. That if you read Article 18 on continental preferences, what you see to me is not continental preferences, but possibility of continental discrimination. Because if an African state grants a favor to another African state, that favor is not going to be granted to all the other members immediately or unconditionally, unless those other members can grant some favors in return. So it is a give and take situation. We will get behind you, but we'll only get, and this is bad for the small African states, because what do they have to give back? The big African states have, can give something back to each other, but I don't know whether the smaller states have anything to give back for purposes of reciprocity. If Kenya decides to enter its FTA with the US, like was discussed previously, it can do that under the AfCFTA. And the only way that other parties can gain the benefits in that FTA with the US is if they grant something in reciprocity. What can the smaller countries, which are not as economically enabled or bigger like Kenya, offer back? It seems as if they will have nothing to offer. And therefore, this provision can have very serious consequences. I see that my time is running out, so I'll go a little bit fast just here. Just to say that my analysis of the MFN rule of discrimination in Article 4 of the Protocol on Goods comes up with this view that, yes, are we really equal partners? If we were equal partners, I think these provisions will have been written in a way that will have granted possibilities for these smaller states to benefit when bigger states enter into agreements with third parties. So, and now we have problems also with the EPA, and Kenya has already entered into an EPA with the UK, which has its own problems within the East Africa community, but wider problems within the AfCFTA. I think Ghana has gone in the same direction too, and we know already that the SADC-EU EPA has been on for a while. So what does that mean moving forward?
Sorry, Harrison, to interrupt you.
Sorry.
No worries at all, and thank you very much for this interesting topic. We are going to go back to it. We're just going to introduce the next speaker, Mrs. Balkissou.
Ok, donc on fait d'abord, je peux faire le résumé de sa présentation ou bien après?
On fera cela après. On va continuer avec le prochain.
Je vais passer la parole au professeur Fulvio Palombino. Il est professeur dans deux universités, l'université de Naples, Federico et l'université de Rome-Luce. Bonne arrivée, Monsieur Fulvio.
So we are gonna listen to Professor Palombino, who is a professor at the University of Naples in Italy. And please, the floor is yours.
Thank you very much. Good afternoon, everyone. Thanks a lot to Mrs. Balkissou for giving me the floor. And of course, let me also thank the African Society of International Law for the invitation. I'm really very glad to be here today. Well, moving on to the topic of my today's presentation, i.e. the African way to investment disputes, I would like to start by recalling that since the very beginning, international investment law has been conceived as biased in favor of investors from both a substantive and procedural point of view. In terms of substantive law, it is well known that the majority of investment treaties usually grant rights to investors without imposing any obligation on them. And in terms of procedure, almost all investment treaties provide the investor with the right to claim a treaty violation before an arbitral tribunal, whereas the opposite is not possible, so that a state cannot start an investment claim. This means that the investor-state dispute settlement system is inherently asymmetric, and this means that, of course, Marty Koskiniemi is right in pinpointing that when one of the parties, and only one of them, may say, if you don't agree with my condition, then see you in the court, then the balance of power has shifted decisively in favor of that party. African states have suffered most from this imbalance, often succumbing in arbitral proceedings against foreign investors and seeing the interests being sacrificed in favor of those of capital exporting countries. Unsurprisingly, the main antibody relied on by the African continent to face this problem consists of increasingly replacing the ICTS system with a range of alternative dispute settlement mechanisms, a tendency which has been described by some scholars as a sort of Africanization of international investment law. More in detail, according to this scholarship, this is a way of overcoming the colonial era through the production of legal knowledge aimed at drawing up substantive and procedural actions which challenge the ICTS and international investment law. This trend is part of the more general criticism directed at the dogmas of international law by third world approach to international law scholars, and it is embodied by different legal instruments such as regional agreements and national regulations. And indeed, a series of regional investment agreements within the framework of the African economic communities try to innovate traditional dispute resolution mechanisms. In 2016, for example, in the context of the African Union, the Pan-American Investment Code was drafted with the ambitious aim of harmonizing continental investment policies. The code is only a guide for future agreements. We are talking about a soft law instrument, and as such it is not binding, but it represents the most ambitious attempt at overcoming investment arbitration and substituting it with a more balanced investment dispute resolution system in African-based centers and domestic courts. This purpose is made evident by several provisions: the introduction of the exhaustion of local remedies requirement before resorting to arbitration, the application of the law of the host state once the dispute has been referred to arbitration, the conducting of arbitration proceedings in African private or public alternative dispute resolution centers, and of course the possibility by the host state to file a counterclaim. The innovations contained in the code are not limited to procedural aspects, but also include provisions designed to affect the substantive treatment of foreign investments, such as a narrow definition of investors, the absence of a provision on fair and equitable treatment, and the imposition of performance requirements on human rights, due diligence, and sustainable use of natural resources. Again, one may consider the economic community of Western African states one of the most relevant and complex regional economic communities, in whose framework the Supplementary Act adopting community rules on investment and the modalities for their implementation with ECOWAS has been drafted. So an instrument aimed once again at harmonizing national laws and adopting a common investment code to guide national investment policies. This act provides for dispute resolution mechanisms, but only through national courts or national investment arbitration centers. Furthermore, it states, that's a very important provision, that all states shall ensure that a legal system and rules allow for and do not prevent or unduly restrict the bringing of courts actions on their merits before domestic courts relating to the civil liability of investors for damages resulting from alleged acts or decisions made by investors in relation to their investment in the territory of other member states, and that the host state laws on liability shall apply to such proceedings. So in other words, in this case too, the investor is entrusted with a number of obligations, among which is the obligation to comply with on e.g. security, health and social welfare in force in the host country. Again, one may consider the 2016 Morocco-Nigeria BIT. We know that it is not it is not into force yet, this BIT, but its innovative character is unquestionable and may be found, for example, in its Article 18, insofar as this article, as this provision recognizes the investor's obligation to respect the environment, to comply with human rights, and to fulfill labor law obligation. In a nutshell, all these instruments share two main common features, meaning the tendency to attract disputes between the host states and foreign investors to domestic courts and national arbitration centers, as well as the provision of a number of substantive obligations on investors. On the other hand, as regards national policies, this has been already said, it is not worthy that South Africa has abandoned investor-state arbitration by terminating its previously concluded BITs and enacting the Protection of Investment Act in 2015 to regulate the matter, substantially limiting the protection of foreign investments. Indeed, its dispute resolution provisions provide for recourse to national courts and state-to-state arbitration, thus excluding international investor-state arbitration. Less radically, Tanzania, for example, also introduced changes in its approach to investment arbitration. Through a series of laws, the government has ruled out arbitration for certain sectors, including mining, and has subjected disputes arising from public-private partnerships to the competence of arbitral bodies in Tanzania and to domestic laws. Now, although these innovations may be read as groundbreaking, the Africanization approach can prove counterproductive for the very countries which promote it. The ICDS system that African countries are wishing to replace in the above-mentioned instruments has been created to grant foreign investors an impartial forum in which they have standing to protect the substantial rights as laid down by BITs. And of course, from this angle, African host states risk sending out the wrong message concerning the commitment to the protection of foreign investments. Well, very briefly, my contention is that to overcome the problems of the so-called Africanization trend, one can resort to the humanization of international law argument. Over the last few years, as is well known, several scholars have been emphasizing the profound impact of human rights on international legal order structure, going so far as to determine its transformation in terms of both personality and sources. This argument focuses on the potential role of individuals as persons of international law, a role, it is argued, which has undergone significant changes over time, precisely as a result of the progressive emergence of human rights law. Still, even though the issue of whether individuals possess legal personality remains in a way contentious, this argument brings about a more general and preliminary question. That is, what rights and duties individuals are entitled and obliged to under contemporary international law? Well, the humanization of international law perspective gives some insights especially as far as the rights of individuals are concerned. Indeed, for a long time, and from this point of view, I'm stating the obvious, individuals did not have rights on international level and were precluded from bringing claims before international courts and tribunals. And the turning point was the adoption of a series of universal and regional human rights treaties providing individuals with effective protection in terms of both substantive rights and procedural rights. As a consequence of this trend, a kind of individual personality, at least sui generis, is no longer questioned by legal scholars, and such a conclusion is, of course, symptomatic, at least, of the plausibility of the humanization of international law argument. But now the question is whether the same argument, which is used, which is relied on from an individual-centric perspective, may be resorted to from a state-centric perspective too, and whether a perspective of this kind may be used within the context of international investment law. My answer is yes, of course, and this is clear if one looks once again at the issue, for example, of individual personality and the normative dynamics behind international investment law. As for personality, the decision in Urbaser versus Argentina is worth being mentioned. According to the decision, it can no longer be admitted that investors operating internationally are immune from becoming subjects of international law. By doing so, and that's the most relevant aspect, the tribunal clearly affirms that the international personality of investors, but with the view to saying that they are recipients not only of rights, for example, the right to due process of law, but also of obligations like those stemming from measures adopted by the host state to protect its population's fundamental rights, including the right to a safe environment, the right to health, and so on. In other words, in the tribunal reasoning, the humanization of international law argument and the personality of individuals, which this argument presupposes, serves the purpose of defending the state's power to regulate in the public interest.
Sorry, Fulvio.
I can conclude just for me.
The time,
Good,
Mr.
thank you.
I'm concluding, yeah, you're
Can
right.
you conclude, please?
Yes, yes, of course, of course. Yes. In other words, okay. Whereas the humanization of international law argument has been originally conceived as a tool to strengthen the individual's position vis-a-vis that of the state, nothing prevents it from being used in a state-centric perspective, and African practice may be fundamental in this respect. So in terms of personality, for example, and to say the least, the investors' liability principles, such as embedded in the ECOWAS Supplementary Act, precisely respond to this need, and if considered in absolute terms, may be of inspiration for the ICTS system as a whole. In a nutshell, and I conclude really, given the fundamental role which has been played by African countries in shaping the current ICTS system and assuming the ongoing importance of this system in increasing investment flows into the territories, I'm of the opinion that the same countries should contribute to its reform by favoring a shift from an individual-centric to a state-centric paradigm. That is to say, by exporting the African approach to international investment law worldwide. Thank you very much.
Thank you, Mr. Fulvio. Thank you very much. Now I will give Je vais donner la parole à M. Ravindra Pratap. Vous êtes professeur associé et doyen associé à la faculté de droit de l'Université South Asian à New Delhi, en Inde. Vous écrivez fréquemment sur les sujets relatifs au droit du commerce international et à l'OMC. Welcome, Mr. Ravindra.
So now we are welcoming Professor Ravindra, Associate Professor at the South Asian University in New Delhi, India, and also Associate Dean of this same university. He's working especially on WTO and international trade law, and the floor is yours, please.
Thank you, Madam Chairperson. I'm also grateful to the African Society of International Law for listing me as one of the speakers in a very distinguished panel. I'm going to talk about facilitating the participation of African countries in WTO dispute settlement, and for which I'm going to explore the possibility of litigation cost. WTO incurred litigation incurs cost and may have continued in some cases for over a decade. By now, approximately more than 600 disputes have been brought to the WTO. Over 40 panel and appellate body reports have been issued. 6 compliance panel proceedings have been completed with findings of non-compliance. But no African country has been a complainant in the WTO dispute settlement. 3 African countries, namely Egypt, Morocco, and South Africa, have been respondents, and only 3 panel and 1 appellate body reports have been issued involving an African country. 20 African countries have been third parties. While this is significant in that the other WTO members have been third parties before being complainants, but none of the 20 African third parties have been complainants. Now, during negotiations on the improvement and clarification of WTO understanding and rules and procedure of settlement of disputes in 2002, the African group argued that the low participation rate of African members is not because they have never had occasion to want to enforce their rights or the obligations of other members, but due to the structural difficulties of the WTO dispute settlement system. It has been noted that the WTO dispute settlement system is complicated and too expensive. It entails high legal cost, and the prospective benefit from litigation, you see, it exceeds the benefit from the litigation, and that the non-participation of African countries in the WTO dispute settlement system is a danger to its predictability function. Now, these difficulties clearly include litigation cost, which have been further noted in the literature as a reason for low level of participation of least developed and developing countries in the WTO dispute settlement system generally, and African countries in particular, as legal capacity has been noted as amongst the most salient variables in empirical studies of WTO dispute settlement system. Now, my presentation looks at the issue of litigation costs from 3 standpoints. First, as a matter of special and differential treatment, then as a substantive issue, and finally as a systemic issue. Now, the first as a special and differential treatment, because that is a continuation of a GATT normative category, which accords a more favorable treatment to developing and least developed countries in the international trading system. Here we inquire whether any African countries have prevailed over or successfully defended against developed countries, since we have found that none of these current cases which have been brought against African countries, 2 by Turkey, 1 each against Egypt and Morocco, and 1 by Tunisia against Morocco, were brought by developed countries. So this part of the hypothesis is not true. However, the lack of legal capacity of least developed countries to bring cases against developed countries has been well documented. As a matter of a special and differential treatment, the African group has quite appropriately proposed the creation of a dispute settlement fund for defraying the cost of litigation. As part of our second inquiry, we considered it to be useful to explore any linkages between the substantive WTO agreements in which African countries have been involved and litigation cost. Now, what we find is that all the 3 cases which had proceeded to panels and 1 of them to the appellate body, although the appeal was withdrawn before it could be further argued, had concerned only 1 substantive agreement, that is anti-dumping measures, anti-dumping agreement, which with 140 disputes by now is the second most frequently litigated substantive WTO agreement. So it is therefore clear that the traditional goods sector has been the subject of most WTO disputes, despite addition of a number of new agreements with the establishment of WTO in 1995. So it is the goods sector which is the most developing and involved in the litigation in which developing and least developed countries have been involved. Now, firstly, in the dispute which was brought against Egypt by Turkey, DS211 case, WTO panel finding, you see, pointed to the fact that Egypt had the necessary legal expertise required for discharging its obligations under the anti-dumping agreement by its investigating authority. However, in the second dispute, which was brought against Morocco by Turkey, DS 153, WTO panel finding underscored the importance of time in concluding anti-dumping investigation, and which in turn does not necessarily preclude the availability of an in-house legal expertise to the investigating authority. Further, it also appears from this panel finding that Morocco did not seem to clearly or fully understand its legal obligation under Articles 6.8 and 6.9 of the anti-dumping agreement, and which could possibly be attributable to the lack of availability of requisite legal expertise domestically, and if compared to the quality of its availability against cost, may also be attributable to that extent to the cost of litigation. Finding of dumping required to be made in accordance with the anti-dumping agreement, and according to which it is the product, not the outcome of any inquiry of dumping, which may be determined to have dumped. Now, insofar as this is also a matter of legal interpretation of the anti-dumping agreement, it is also a matter of the availability of a proper legal expertise to the importing country. The panel found finding in the Morocco's failure to comply with the Articles 3.1 and 4, which was based on the absence of due consideration of evidence also. Finally, we also inquired whether there were any WTO cases in which complainants have successfully litigated. We inquired also whether there was any cases in which the complainants had litigated successfully non-compliance. Now, the reason is why, because where the WTO says, dispute settlement understanding says that it is the discretion of a member to invoke the dispute settlement understanding, where it believes that it has you see, any member has diminuted its rights and obligations. But the point is this: DSU, that is dispute settlement understanding, nowhere states either that the recommendations of WTO and the ruling shall not be duly complied with, or that the affected party prefer a mutually agreed solution to withdrawal of a WTO inconsistent measure, much less to require that a member to exercise his judgment whether the action to bring about, to bring in against WTO, against another country, to bring its measure in compliance would be fruitful, because if the action is considered for compliance and not for bringing a case. So there is a distinction between invoking the system, to litigate rights and obligation, and to ensure compliance with a successfully litigated case. Now, if the balance between the rights and obligations of members is not considered to have been disturbed, if restored within a reasonable period of time under the DSU, it follows that the compliance with DSB recommendations and rulings not ensured within a reasonable period of time would perforce be deemed to have disturbed the balance of WTO members' rights and obligations, because there is a provision in DSU for compensation if the compliance is not complete within the reasonable period of time. And that's a very important point, which underscores our third proviso, that if there is non-compliance and the case is brought against it. So in other words, it is not just fault which is found with compliance, but also a systemic presumption of actual damage as from the end of the reasonable period of time that affords a basis for claiming cost of litigation.
And sorry, Ravindra, to interrupt.
Special and differential treatment. So just one minute. So
yes,
therefore,
please.
This is the point that it is as a matter of systemic issue. It does not require the basis of the special and differential treatment. Now, since there is no case in which this has happened in the African case, so this hypothesis is also not proved in the cases on empirical plane. But then this remains a very sound argument to claim litigation cost as a matter of systemic issue. Thank you very much for your attention.
Merci, Monsieur Ravindra. Merci beaucoup. Et je remercie vraiment tous les panélistes Et je crois que Karim, je vais peut-être procéder au résumé de tout ce qui a été dit.
S'il vous plaît, de manière très courte en tout cas, mais s'il vous plaît.
Très courte, oui. Ok, je vais d'abord revenir à M. Mbori. Et dans sa communication, il a fait ressortir les raisons du choix du principe de la nation la plus favorisée par les rédacteurs de l'accord cadre et des protocoles de la ZLECAf en étudiant et aussi bien en analysant les documents préparatoires, ce que cela pourrait soulever pour l'avenir du commerce international en Afrique. Selon le présentateur, le choix du principe NPF conditionnel, parce qu'il dit que c'est tellement conditionnel dans le protocole, dans les protocoles, et que ça montre que les États africains ne sont pas encore prêts pour la libéralisation du commerce total, et que certains membres de la ZLECAf offrent aux pays non africains, c'est-à-dire les pays qui ne sont pas membres du continent africain. Donc, dans la présentation, M. Harrison avait également soutenu que le fait d'avoir ces différentes variantes de l'obligation NPF dans le cadre d'un acquis unique, c'est-à-dire comme l'accord cadre de la ZLECAf, s'avérera tellement déroutant et que les groupes spéciaux et l'organe d'appel du système de règlement des différends de la ZLECAf auront vraiment du pain sur la planche, si je peux dire. Donc, c'est ça en résumé ce qui ressort de la présentation de M. Harrison Mbori. Et je peux peut-être lui poser des questions avant d'arriver.
Alors, on va devoir conclure malheureusement, donc si vous pouvez résumer les présentations et ensuite on va devoir passer au panel suivant malheureusement par manque de temps.
On ne peut pas, moi j'ai des questions, hein. Ou bien on laisse les...
Ou alors vous pouvez poser les questions.
Et on pose les questions.
Alors vous pouvez poser vos questions directement et on demandera des réponses très courtes de 1 minute.
D'accord. Et pour
une question Harrison, chacun.
Une question. OK. Et donc, pour M. Harrison, je voudrais savoir quel serait l'impact commercial plus large et général pour le développement de l'Afrique si les obligations du principe de la nation la plus favorisée étaient interprétées harmonieusement. C'est ça ma question.
Je vais essayer de bien résumer, vous me dites si c'est bon. Okay. So, Harrison, what would be the consequences of having a harmonized interpretation of the MFN clause for the African trade?
Yeah, thank you.
In 1 minute, please.
Yeah, for that question, there are many. I think there are many impacts of commercial impacts of this provision. It seems to me that if it is interpreted harmoniously in a way that makes it more difficult for African states to enter into third-party agreements, then there is hope. If it is interpreted in a less, in a very, free manner that allows African states to enter into third-party agreements, then there is going to be a big problem. So it's going to be a balance, first of all, on whether African states are going to take cases to the, dispute settlement system and say, Ghana, Kenya, South Africa, Egypt, you cannot enter into a third-party agreement with these big states unless you show that they're not going to undermine the AfCFTA. Because I am sure that any big agreement, especially if you enter an African state enters into an FTA with a big country, say the EU or the US, has a high potential of undermining the AfCFTA. So the interpretation has to be one that really limits the scope and the extent of such agreements. That's what I would say. Thank you.
Merci, M. Harrison. Je reviens à M. Fulvio. Et votre communication nous démontre qu'il existe vraiment une alternative possible pour les États africains et que cette alternative repose sur une réforme du mécanisme à l'intérieur même et par la promotion de l'argument de l'humanisation du droit international. dans une perspective centrée sur l'État. Donc, c'est que je voudrais, la question que je voudrais vous poser, vous savez, au niveau du secrétariat, nous sommes en train d'élaborer le protocole sur l'investissement. Et il n'est pas sans savoir qu'il y a un programme de la Banque mondiale, DB, sur la protection des investisseurs, surtout minoritaires. Donc, ce programme de protection des investisseurs minoritaires de la Banque mondiale, dans la plupart de nos États africains qui sont membres, et il y a une notation qui se fait à chaque année. Donc, ce programme a mis en place la voie à suivre, comment les États africains, ce que les États africains doivent faire pour promouvoir les investisseurs, que ce soit les grands investisseurs, mais ce programme protège surtout les investisseurs minoritaires. Pensez-vous que dans le cadre de la rédaction du protocole sur l'investissement au niveau de la ZLECAf, on peut s'inspirer de ces lignes directrices élaborées par le programme de la Banque Doing Business de la Banque mondiale? Merci.
So again, I'm going to summarize the words and question of Mrs. Balkissou, but Fulvio, we would be interested in knowing whether African states and above all the AfCFTA Secretariat should take into consideration and for inspiration the DB program, Doing Business program, created by the World Bank.
Le programme qui a trait à la protection des investisseurs.
Yeah. So, my answer is yes, of course. I think you should take this into account. But what I would like to add, I didn't have time during my presentation, is that in this moment, there are a lot of countries like Italy, for example, which look at the African practice as really a model. If I take into account, for example, the new Italian model BIT, there are a lot of provisions which have been written and drafted having regard to the Morocco-Nigeria BIT. So, of course, if you ask me whether African states should take into account this program, I say yes. But please consider that there are a lot of countries all over the world, including Italy, which take into account African practice in drafting the model BIT. So I think this is something very significant in order to, when I say that this approach, the African approach, has the potential to be exported worldwide, I'm really convinced that this is possible. Yeah. Thank you.
Thank you.
Thank you. On va en prendre note parce qu'on est en train d'élaborer. La semaine prochaine, on va commencer l'élaboration du protocole sur l'investissement dans le cadre de la ZLECAf. Merci beaucoup, M. Fulvio. Là, je vais revenir à M. Pratap.
Alors, Madame Balkissou, si vous pouvez juste poser votre question. En 1 minute, s'il vous plaît, parce que nous sommes en retard.
Okay. Il avait sa présentation a tourné autour des coûts et du manque de saisine en fait que beaucoup d'États ne saisissent pas le système de règlement des différends de l'OMC. Ma question est de savoir que pensait-il de l'état actuel de l'examen en appel au niveau de l'OMC? L'organe d'appel de l'OMC, qu'est-ce qu'il peut nous dire sur son fonctionnement? Parce que nous, on est au niveau de la ZLECAf, on est en train dans le processus de la mise en place de l'organe d'appel et l'organe a été déjà établi par l'ORD et la sélection des membres va suivre. Donc, on est dans le processus de mise en place. Est-ce qu'il peut nous dire qu'en est-il au niveau de l'OMC? Merci.
So Ravindra, if you can quickly share your thoughts on the appellate body of the WTO dispute settlement mechanism, and whether you have also advice to improve the mechanism for the next dispute settlement mechanism with the AfCFTA.
Yes, you see, the appellate body at the moment is not functional because of the non-availability, non-election of members to the appellate body. And now, there have been some, you see, suggestions, some alternatives to the appellate review, in the sense that it could well be dispensed with as long as there is no political will to revive it by nomination election of members by way of recourse to some sort of arbitration, which had been suggested by you see a draft proposal, you see, by the European Community. Well, that is to be seen, well, how it goes. But as far as you see, some of the least developed countries and developing countries in general are concerned, that is what what I talked about in my short presentation was that we need to, you see, propose, mechanisms for that, by which an effective use may be make use of the system, and not necessarily as a matter of special and differential treatment, but it is also as a matter of systemic issue, because the deal, that is the dispute settlement understanding, promises that the balance of rights and obligations of members shall at all times be preserved. So in other words, if that balance has not been preserved, then it is a systemic issue. And whether it is at appellate level, whether the litigation proceeds at appellate level and or at the level of panel, the argument holds good, at both the levels.
Thank you very much, Ravindra. So we are going to end the session with some words from Makan, who is going to deliver a quick speech, and then we'll turn to the two other panels that we have scheduled.
Merci beaucoup, je remercie. Thank you for all. Je remercie tout le monde. Bye. Et je vais envoyer mes questions en réalité pour les autres, surtout pour Monsieur Fulvio concernant la protection des investisseurs.
Magnifique, magnifique. Merci beaucoup, Madame Kabo, pour cette excellente modération. C'était magnifique. And thank you so much to Fulvio, Harrison, and Ravindra. That was a terrific panel, and we wish we could continue the discussion, because there's so much food for thought. But thank you so much. And we are going now to have the next two panels, and I will let, of course, Karim introduce the chairs, but I wanted to thank very much Dr. Edefe and Maître Eri Ranjeva for having accepted to chair the next two tracks, and thank very much the speakers, the keynote speaker, Professor Edward Kwakwa, Professor Falou Samb, and all the great colleagues that are going to speak. I'm sorry not to be able to attend the next two tracks, because I have to teach now in 10 minutes in Paris. So I'll make sure to watch the recordings, but I wish you great sessions, and I'm looking forward to seeing everybody tomorrow for the other session. But I wish you all great sessions now, and thank you again to Edefe and Eri for sharing. Thanks, guys.